Hello everyone. Today we are going to start some important section, law series on the important section. I will be dealing important section that is basically a parent and its interpretation. So before going to start, I would request that please take out your parent and read by line with me. We will start from this section 22 of the BNS, that is section 84 of the IPC, which talks about the act of a person of unsound mind. When we talk about the act of a person of unsound mind, he is generally exempted from the criminal offences under chapter 3rd. When we talk about the section 22 of BNS, we have to read section 3 clause 1 of the BNS. What does the 3 clause 1 of the BNS says? It basically links the offences with the general exception. जब हम सेक्शन 3 क्लॉज 1 की बात करते हैं तो सेक्शन 3 क्लॉज 1 जो बात करता है इट इज़ बेसिकली ए डिक्लेयरिंग क्लॉज. वो डिक्लेयर करता है, इट डिक्लेयर्स बेसिकली वॉट एवर द ऑफेंसेस अंडर दिस संहिता विल बी also has to be read with the general exception that is provided under this संहिता. तो जो भी जनरल एक्सेप्शंस हैं BNS में, it has to be read with every offenses because every offenses, every provisions, every illustration cannot describe the general exception. So we have to read. So जब हम बात करते हैं when we talk about the act of an unsound mind, so what is the legality behind making the act of an unsound mind person excusable from the criminal offenses? So here we will understand the interpretation of the parent. Let's start. Nothing is an offense which is done by the person who at the time of doing it by the reason of unsoundness of mind is incapable of knowing the nature of the act or that he is doing what is either wrong or contrary to law. So when we read that nothing is an offense, the section itself starting in a negative connotation, which means anything which is an offense in this saita, that is punishable in this saita, if it is done by that person who at the time of doing it, it means the burden of proof lie upon the accused to prove that at the time of doing the act he was suffering from the medical unsoundness of mind. So हम एग्जाम्पल समझते हैं. जैसे ये है अनसाउंड व्यक्ति है. लेट्स सपोज ही कमिटेड द मर्डर ऑफ द बी. उसका ट्रायल हुआ मर्डर का. देन ही एक्चुअली क्लेम द डिफेंस. वो डिफेंस क्लेम करता है. He claimed the defense of section 22 of the BNS. ठीक. तो what he has to prove? Proof क्या करना पड़ेगा उसको? What he has to prove? Whether he has to prove that he was suffering from the unsoundness, or he has to prove that at the time of doing he was suffering from the unsoundness. So here the word at the time of doing it says that the burden of proof lie upon the accused, that he has to prove the burden, he has to prove that when he was committing the crime, when he was committing the murder of the bee, he was suffering from the unsoundness. Now this burden of proof which lie upon the accused, the question arises whether he has to prove this burden of proof beyond the reasonable doubt or till the preponderance of probabilities. So basically difference क्या होते हैं preponderance of probabilities and beyond the reasonable doubt? See, beyond the reasonable doubt का मतलब होता है whenever the prosecution proves his case. Suppose let's say there has been a murder and prosecution has to prove the murder. Then he has to prove the case beyond the reasonable doubt. Beyond reasonable doubt means everything he has to prove the chain of all the circumstances. He has to complete the chain of circumstantial evidences. Beyond the reasonable doubt means he has to prove those evidences which are necessary. He has to prove the ingredients as well as those evidences which are required for that offense. Not just mere the facts of the cases or mere the circumstances of the cases or mere the uh, just mere the surrounding of the cases. So when we talk about the preponderance of probabilities, it means that whenever the person who is a reasonable person would behave under the similar surroundings, so same reasonable person is when behave in the similar surroundings, that pro- circumstances are attributed upon the accused. So preponderance of probabilities means surroundings, circumstances of the cases. So when burden of proof lie upon the accused to prove that at the time of doing the act he was suffering from the unsoundness, so he has to prove till preponderance of probability. Matlab, he has to prove those circumstances that he was suffering from this disease, mental disease, at the time when he was committing the murder. This is the one part of this section. The second part requires the legal unsoundness, which is explained here. I will read the whole section again. Nothing is an offense which is done by the person who, at the time of doing it, by the reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. Now, here, he is suffering from the medical unsoundness. He has to prove that at the time of doing it, he was suffering from the medical unsoundness. Now, this is not sufficient. Why? Because he has also to prove his incapability regarding the knowing of this nature of his act. He has to prove that at the time he was suffering from the mental disease, as well as he has to prove that he was suffering from the incapability in knowing the nature of his act, or he can prove that he is doing what is either wrong or contrary to law. Now this means that he has to prove the medical unsoundness, which is unsoundness of mind, but he also has to prove the legal unsoundness. Legal unsoundness and medical unsoundness both has to be proved for the purpose of taking the defense under section 22 of the BNS. If I say in Hindi, तो हिंदी में मैं बोलना चाहूँगा that जो भी डिफेंस ले रहा है अनसाउंडनेस ऑफ माइंड का, उसको दोनों चीज़ प्रूव करनी होगी. पहला अनसाउंडनेस, दैट इज मेडिकल अनसाउंडनेस. दूसरा लीगल अनसाउंडनेस, दैट इज रिगार्डिंग द इनकैपेबिलिटी नोइंग द नेचर ऑफ द एक्ट, or he can prove his incapability that he is doing what is either wrong or contrary to law. These two things he has to prove अगर उसको डिफेंस लेना है for unsoundness of mind. Now this section has to be read in a whole. The ingredients has to be proved for purpose of taking the defense. When we come on the later part, uh, or that is doing what is either wrong or contrary to law. So when we talk about the word either wrong or contrary to law, so wrong, what does the wrong implies? Wrong का मतलब क्या है? Here the wrong would mean moral wrong, and the word contrary to law here would mean legal wrong. Now the question arises whether he has to prove moral wrong or he has to prove legal wrong. Now here the case, the name of the case is Bapu at the Gujarat versus State of Rajasthan. I repeat, Bapu at Gujarat versus State of Rajasthan, 2007 Supreme Court. In this case, it was held that the accused has to prove either of the two parts, later parts. Either he can prove his incapability of knowing the nature of his act, or he has to prove both the later parts simultaneously. That means he has to prove that what he was doing is either wrong, and as well as contrary to law. It is legal. It is not sufficient for him to prove the word moral wrong. He has to prove moral wrong as well as the legal wrong. So मैं इसको हिंदी में कहना चाहूँगा कि उसको बेसिकली या तो इनकेपेबिलिटी प्रूव करनी है, लीगल अनसाउंडनेस की इन नोइंग द नेचर ऑफ हिज एक्ट, या फिर वो प्रूव कर सकता है कि उसको पता नहीं था डेट ही वॉज डूइंग, या तो वो मॉरल रॉन्ग एंड एज वेल एज लीगल रॉन्ग, यानी कि वर्ड मॉरल रॉन्ग विल गोज अलॉन्ग विद द लीगल रॉन्ग. There was another case that is called the landmark case, and इस section के संग we actually read this case. This case named as R versus Daniel Magnoton, 1843. This case was actually the judgment given by the Lord Tyndall. It is basically related to the insane delusion. When a person is suffering from the medical deficient, that is medical incapacity, that is actually medical disease, insane delusion, so then he has to prove the legal unsoundness also. He has to prove the incapability of knowing the nature of his act also. So in this case, it was held that even though he is suffering from the medical disease, that is medical deficit, but he has also has to prove that he was incapable in knowing the nature of his act, or what he was doing is either wrong or contrary to law. It means here we came again on the conclusion that both the ingredients, that is medical unsoundness and the legal unsoundness, has to be proved by the accused for the purpose of taking defense. This whole section 22 BNS here completes. There's another section, it is section 108 PSA. It is Bharatiya Sakshi Adhiniyam of 108 PSA, which talks about that the court will generally presume the absence of general assumption. So the burden of proof will be more strict upon the accused, but it will only till the extent of preponderant probability. So here I conclude my all the information that whatever the act done by the unsound person will only be available for the defense when he proves medical unsoundness as well as the legal unsoundness, and that too the medical unsoundness should be at the time of doing the act. So thank you very much. I hope you will understand the whole of the section, and I will be coming with more of the other section and more videos. Thank you so much.